you been served with a protective order, or are you seeking a protective order against someone else? I'm Morgan Lay, an attorney with substantial experience handling all aspects of protective orders, here to give you some important information about protective orders in Maryland. Subscribe to my YouTube channel and Markham Law Firm's YouTube channel for more information on important legal topics that matter to you. So what is a protective order? A protective order is a court order that prevents another person from contacting, harassing, assaulting, or abusing the petitioner. The petitioner is the person who filed the order. The respondent is the person who is served with the order. There can also be cross petitions where both parties have filed protective orders against each other. A parent or guardian can also file a protective order on behalf of a minor child. So who can get a protective order? To get a protective order, you must be a person eligible for relief. A person eligible for relief is one of the following: the current or former spouse of the respondent, a cohabitant of the respondent, a person related to the respondent by blood, marriage, or adoption, a parent, step-parent, child, or stepchild of the respondent, or the person eligible for relief who resided with the respondent or person eligible for relief for at least 90 days before the filing of the petition, a vulnerable adult, an individual who has a child in common with the respondent, and an individual who had a sexual relationship within 1 year with the respondent, an individual who alleges that the respondent committed a sex offense against them within 6 months of filing the order. What does the petitioner have to prove to get a protective order? A petitioner must show by a preponderance of the evidence, or more likely than not, that the respondent committed an act of abuse. An act of abuse is defined as an act that causes serious bodily harm, that places a person eligible for relief in fear of imminent bodily harm, assault in any degree, rape or sexual offense, stalking, or revenge porn. What sort of evidence can be presented at a protective order hearing? Anything that supports your case, regardless of which side you are on. Testimony, photos, social media posts, videos, and emails are the most common types of evidence. So what do I need to do if I'm the respondent? If you are the respondent, protective orders can have major consequences. You will be ordered to turn over any firearms, and you will be prohibited from possessing a firearm for at least a year if a final protective order is issued. You could be ordered to vacate your home even if your name is on the deed or lease and you are the one who pays the rent or mortgage. Custody of minor children and pets may be awarded to the petitioner. You will be ordered to have no contact or no harassing or abusive contact with the petitioner for at least 1 year. If you have a security clearance or sensitive job, a protective order can result in your security clearance being revoked and your TSA clearance being revoked. So, do you have remedies if a protective order is issued against you? If your protective order started in the district court, you have the automatic right to appeal to the circuit court within 30 days of the final hearing, where you can have an entirely new trial or consent to the order. You could also file a motion to modify the terms of the order during the duration of the order. What happens if there is a violation of the order? Violation of a protective order is a criminal offense punishable by up to 90 days in jail and a $1,000 fine for a first offense, and up to 1 year and $2,500 for a second offense. So, should you consent or have a hearing? Well, if you consented to the protective order, a judge will enter the order without making a finding that an act of abuse occurred, and the protective order records can later be shielded. If you request a hearing, the court is going to decide whether the petitioner has shown that it is more likely than not that an act of abuse occurred, and will enter the order with terms that the court deems appropriate. If a finding is made, you may not be able to later shield the records unless the case was appealed and there's no subsequent finding by a court. Do I need a lawyer for a protective order? While having an attorney is not required, and there's no right to court-appointed counsel, an attorney can be very important in presenting your case. The rules of evidence still apply in a protective order hearing. In addition, attorneys can negotiate with the petitioner where the respondent is not permitted to contact the petitioner, and an attorney can advise on the best course of action in your particular case. I hope you found this information useful. Like and subscribe and send any requests for the topics in the comments below this video. I'm Morgan Lay, and I'll see you next time.